talking about do I inherit my parents' debt, and a few other sort of miscellaneous topics that we have that we get a lot of questions on in particular. So hopefully you'll all be interested in that. Coming up in our March topic is our very sort of keystone webinar that we do, or program that we do, that we call wills versus trust. It's just some background on the differences between those two things. And a lot of people don't really understand exactly the difference between a will and a trust, and they don't understand what a will actually does for them and how to properly use either of those tools. So it's a really interesting topic. It's one of our favorites to talk about, obviously, and you usually get a lot of good questions. So if that interests you, please feel free to sign up for that. But our topic today is definitely more focused and more geared towards things like what's the best way to deal with debt in an estate, and what's the how do I make sure that things are properly paid for. So welcome everybody again. I'm attorney Justin Randall with Hooper Law Office. Our topic today is, do I inherit my parents' debt, or do my children inherit my debt if you're the parent? So, that's going to be one of our main topics today. We also have a couple other miscellaneous topics which cover a lot of common questions we get. So I'll talk a little bit about a couple different things here, but if you are joining us via Zoom, you will be able to participate in this webinar by asking questions. So if anything comes up that you have a question on, please feel free to submit it to the Q&A box, and I will be able to see it pop up and answer it while I'm talking. And we will also be receiving some materials from us at the end of this. It's our 9 top estate planning myths, and what the reality is versus what people often hear, kind of on a few different common misunderstandings. And there's also a feedback form that you'll receive at the end of this that if anything I talked about today raises concerns for you, or you want to come in and talk to one of our attorneys, you can fill out that form and say that you would like us to reach out to you to set up an initial consultation. Those are usually set up for around 2 hours, and they are complimentary, so they don't cost you anything to come talk to us. As if you're a regular webinar listener, then you'll understand that we like to get to know you guys before we can really design an estate plan. It's really more so about your situation and your families individually than it is about how much money is in an estate, for example. It plays a factor, but it's not usually the most important thing for people's concerns. So okay, so to get started, the main question of today is, do my children inherit my debt when I pass away? In about half of the states in the country, there are things called filial responsibility laws, which essentially say if a parent is destitute, if they're unable to pay for certain types of expenses, and those expenses that are defined by each state vary. So I can't give you an exhaustive list of them just because they vary so much, but they usually include things like medical care, housing expenses, support for, food, all of that kind of stuff. So I think it's about 23 states or so, if I'm remembering correctly, have laws related to that, where a child, if they are able to pay, if they're found to be able to pay, may become responsible for paying those expenses for their parents during their lifetime, which can therefore turn into a debt that they sort of inherit from their parent when that parent passes. Thankfully, for all those of you who I just gave a major panic attack, in Wisconsin, we don't have laws like that. We don't have a law that says you inherit your parents' debt unless you, for example, were like a co-signer on something where you also made yourself responsible for that debt. So we don't have what they call those filial responsibility laws, where you are responsible for paying a parent's medical expenses or living expenses. Obviously, there's a difference there between what you're legally required to do and what, if you're able to do, you can, morally help them through those difficulties with. But that's not related to actually inheriting their debt. The way debt works when someone passes away here in Wisconsin, if somebody has what we call a deficit estate, so they owe more money than they have assets in the in the estate, going through the estate, a very common tool is somebody will actually initiate a probate so that they can give notice to all the creditors, and the court can look at all of the assets and say there's not enough here, we'll pay off the creditors with what we can. But after that point, it sort of functions like a bankruptcy where the estate, once the money is exhausted, the rest of the claims are, those creditors can't necessarily recover. They certainly can't go after the children or the family of the deceased. So it's sort of like a bankruptcy here in Wisconsin when someone passes and there isn't enough to pay for. So sort of response or related to that, excuse me, is can my children be held responsible for my nursing home expenses? And do they have to pay for those? And what happens with that after I pass away? Similarly with other debts, are they responsible for that? And again, in certain states, that may be the case. And actually, I believe in some states, they've even held that, they can recover in civil court against these children if they're able to pay for long-term care expenses. Again, in Wisconsin, that's not the way it works here. If somebody passes away and they have received long-term care and have been on Medicaid, a recipient of Medicaid while they were receiving that care, Medicaid in Wisconsin, Wisconsin has what's known as estate recovery, where Medicaid can actually come in as a creditor of the estate and recover for what they provided in care. So they keep a running tab, essentially on everybody they've provided care for and what they are entitled to receive in return. There are, again, that's not something that children themselves are responsible for, because in Wisconsin, you're not inheriting your parents' debt. That may vary, again, if you were, you signed something with a nursing home or with an assisted living facility that said you were, obligating yourself to pay, but that's almost unheard of. So I wouldn't worry too much about that. Okay, so I do have a question here. I have a friend who is on disability who doesn't file income tax. Will there be any liabilities and tax for his family to pay after he dies? So that ultimately depends on certain tax thresholds. They do not, family is not responsible for someone else's back taxes again. It's similar to any debt that way. The estate may owe taxes and it may lessen what that family ends up receiving if there's any inheritance there. But generally, family is not responsible for themselves individually, not responsible for the back taxes owed. There are certain assets that you can inherit, like an IRA or a 401k, for example, where the tax had never been paid by the person putting the money into them. And then as the family takes their inheritance from those accounts, they do have to pay taxes on it. But that's not someone being responsible for back taxes owed. It's just the type of asset that they inherited. So with disability income, if they're not filing taxes, that may be because of the fact that they're under a certain tax threshold as well. Similarly to how some recipients of Social Security retirement are not, are below a certain tax threshold for filing too. So it really depends, but the family themselves would not be responsible now. So with estate recovery, though, with nursing home expenses, there are things that people can do to prevent estate recovery from basically taking assets from the estate. That is certainly a very complicated topic that we've talked about in the past, and is sort of due its own webinar because of how complicated it can get. But generally speaking, estate recovery is limited to recovering, against certain assets. It can recover against a probate estate. It can recover against revocable trusts, but it cannot recover against certain types of irrevocable trusts. So there are things people can do with long-term care planning to not only set aside assets so that they don't have to spend down all the way to the Medicaid limits, but so that they can protect what they did set aside from estate recovery and make sure that maybe they're providing for a child who needs those assets after they're gone as well. So during your lifetime too, children can't be responsible for your nursing home expenses. That's exactly why you hear about people talking about spend down and spending down to the Medicaid limits so that they can, end up on Medicaid and then have Medicaid pay for them. And then again, the family themselves is not personally responsible for that. There are things you need to be aware of when you're planning for long-term care that it often involves people talking about making gifts to the children or to the grandchildren or to their other family members to avoid having that money eaten up by long-term care expenses. That can cause you yourself issues when trying to get on Medicaid. But once that money is gifted to the children, they're certainly under no real obligation. Once somebody has received a gift, they're not under any obligation to return that gift. So the nursing home can't come against them, but it may cause yourself some issues there when you're trying to qualify for care and qualify for assistance from Medicaid. So it's just something to be very cautious of when you're looking at preparing for long-term care expenses. But just like with other debt, they cannot recover against your children if you failed to pay for your own long-term care expenses here in Wisconsin. One sort of common question, sort of moving on from inheriting debt, one common question that people have is, well, what happens to my digital assets when I pass away? Digital assets being things like, your like airline points and iTunes accounts and different various social media accounts and passwords and things like that. And for some digital assets, it depends a lot on what the terms of use say. I know Facebook, for example, has basically kind of a beneficiary designation almost for what happens when someone passes. So you kind of designate a successor account holder so that they can, either delete the account if that was your wish or take the photos that you had off of it. But there are other things you can do as well with certain digital assets where you can designate them through an estate plan, as long as it's incorporated properly. And if during your lifetime you're concerned about what happens to digital assets, in Wisconsin, we have something that passed in about 2016, I believe, called the Digital Property Act, which now allows us through a financial power of attorney to have a financial power of attorney agent manage those digital assets during, somebody's incapacity or when they're unable to do so themselves for whatever reason. As I always tell my own clients, though, just because you're allowed to do something like that through a power of attorney doesn't necessarily mean a multinational corporation like Facebook is going to want to make it easy for you. So sometimes it's worthwhile looking at what their terms of use are. I know those are so much fun to read, but taking a look at those and seeing what happens with those, either that information or those assets after you've passed away, and what their sort of default is for those. A very common question we get in general is, well, all of my accounts have payable on death, or they have transfer on death designations, so beneficiary designations on them. Is it possible for me to basically do that for everything I own and have everything in the world, that I could possibly own pass via payable on death or transfer on death? And a lot of assets you can put certain designations like that on, but that doesn't mean it's a good idea to do so. There's nothing inherently wrong with payable on death or transfer on death as a tool, but they're not a plan because they're different for each company. They're sort of backups of what happens if a beneficiary passes before you are going to vary company by company. So who inherits if my son passes before me, for example, something like that. They're going to vary so much company by company, and it's so many different places that you have to keep track of all these things that it's hard to consider it a good plan because it's just all over the place. If you change beneficiaries, you have to change them on all accounts. And depending on how many accounts you have, that can be a huge hassle and takes a lot of time. But it also doesn't, payable on death and transfer on death also do not account for a lot of things that can and sometimes do go wrong when somebody is administering an estate. So that's things like, well, what happens if my beneficiary has a disability that I didn't see at the time, or didn't know about at the time, or just didn't exist at the time I named them initially, but now they're inheriting and they're on some sort of means tested disability program where they can only have so much without losing their benefits? Or what happens if I named my grandchild as my beneficiary, and then 25 years had passed and now that grandchild has a substance abuse issue that when they were an infant, I didn't, couldn't have foreseen them having. So what happens in those instances when somebody is listed as a beneficiary on those accounts? Unfortunately, with a lot of beneficiary designations, and almost all the time, actually, they're paid directly to that individual, which once money goes to an individual, that money is their money. It's a countable asset if they're on any sort of disability program, or if they're a child with special needs. It is available to their control if they have any substance abuse issue, and they can certainly use it however they decide to use it at that point. But it can also go to somebody who is not otherwise doesn't have substance abuse issues, but or doesn't have any sort of disability that would prevent them from having a certain amount of money, but they're just young too. I mean, an 18-year-old can inherit money. That doesn't mean an 18-year-old should be in charge of a lot of money necessarily. They don't have the life experience for it. So it doesn't really account for all of those sorts of life things that can go wrong. And there are certain things you can do through an estate plan as well, like a will or a trust, that allows you to set up creditor protection for your beneficiaries. So if they have creditor claims, or they have, a divorce coming up, or a lawsuit liability that they have to pay something towards, their own assets are at risk for those things. So once you leave something to somebody through a payable on death or a transfer on death, that pays to that individual, and it's available for those concerns. Especially with marriage and divorce, if it gets commingled into a joint account, which happens a lot. I mean, it's pretty easy to accidentally commingle your assets. So payable on death or transfer on death can certainly be used as tools, but they have to properly align with your will or your trust that you have set up, with the terms that you have in there, to make sure that what you thought was going to happen actually does. And a good will or a good trust is going to have provisions in there that say, even if I could not have foreseen this happening to any of these beneficiaries, any beneficiary who is subject to claims, or becomes disabled, or has a substance abuse issue, any of those types of concerns, a good plan will have that in there that says, if that happens, here's the way that their assets get handled by either someone else, so that someone else is in control, or sets it up in a way that it is not available to their creditors. So there's a lot you can do there that just leaving somebody a bank account through a payable on death is not going to do, especially if you name them as an individual. Another common misconception people have, or I guess they think they're being more efficient this way, but it can actually create more problems, is when somebody names someone as the personal representative of their estate, or the what you may have heard of as an executor. When they leave that person the account as a payable on death directly to that person, so that they can pay for expenses right away, they can pay for whatever they need to, and then split up the money to the beneficiaries. And the issue with that is, once that person receives it as a beneficiary, they're the beneficiary. They own that money. So you're not guaranteeing that your plan is going to be followed, because now that person is the beneficiary, they're under no obligation to, once they've actually received that money in their own name, they're under no obligation to share it. They may want to do so because hopefully the person you've named is trustworthy and wants to follow your wishes, but they're certainly not obligated to. And under some circumstances, they may not be able to, if they themselves are subject to creditor claims, or in the middle of a divorce or a bankruptcy. In those circumstances, when you're going through those types of proceedings, you can't necessarily just give money away, because the court would look at that and say, that's what they call a fraudulent conveyance. You're giving money away when you have other responsibilities to cover with that money instead. The other concern that is created when somebody just leaves money directly to one person when they've named them as a personal representative for the estate is that the will, if you're using a will for your plan, wills only control assets that go through probate. So if you have some money go directly to that person, as I mentioned before, they're not required to follow the terms of the will anymore. But also, if you don't have money in the probate estate, and you have creditors come forward, you're not allowing that personal representative potentially to have the money they need to pay creditors, especially if maybe you didn't name the personal representative as the beneficiary on an account and left it all to your grandkids or somebody else. Well, now they don't have any money in the estate to pay for expenses, and they don't have any money in their own name to pay for expenses. And there is no guarantee that they're ever going to get that money from those beneficiaries because one, they're not required to give it back necessarily, and two, they may not be able to again. So payable on death and transfer on death sound very simple. They sound like good plans in theory. And I hear a lot of people say things like, well, it worked out fine for my parents, or it worked out fine for so-and-so. And that's good. It's good that nothing went wrong, but it certainly doesn't provide you a guarantee that nothing will. And it actually, in a lot of ways, is technically not doing things correctly if somebody has a will and they never administered a probate because of it. So you want to make sure that if you're using payable on death or using transfer on death designations on accounts, that you have you work with your attorney and you work with your financial advisor on that to point those designations in the right direction, whether that be directly to somebody's estate. And that's going to, whether that's a good idea for certain accounts is going to depend a lot on the type of asset that it is. Or whether if you have trusts being set up for minors, for example, that you have it directed to those trusts rather than to that minor as an individual. So there's a lot of different ways that these can be tweaked, but you want to make sure that you're doing it properly. And you're not expected to know how to do this on your own, or certainly don't rely on the internet, please, because the internet is either wrong a lot of times, just outright wrong, or you're looking at laws or rules from states that don't apply to you. And it's, that's why people like me and people like financial advisors have jobs, right? That's what we do for a living, is make sure that those things are followed properly according to our rules here in Wisconsin. Okay, so kind of going back to nursing home expenses again, this is something that comes up a lot with the question of, well, my husband or my wife is going into care. How do I make sure that I'm protecting, myself from my spouse's care? Is it okay for me to just put all of the assets into my own name, and therefore, none of it is in their name and it's not available for their care, is the thought behind it. But unfortunately, the way Medicaid calculates available, or what they call the spousal impoverishment provisions, what the spouse is allowed to keep while they're what they call the institutionalized spouse is receiving care. How they calculate what that spouse is allowed to keep while still living at home and being healthy is based off of a lot of joint marital assets, regardless of how it's titled. So they have certain assets that they say for the healthy spouse are unavailable and not counted against the spouse receiving care for Medicaid purposes. And specifically, those are qualified retirement accounts in the healthy spouse's name are not available for their spouse's care. Some very small life insurance policies, you can have a total of $1,500 in face value before they start looking at what the cash value is as an asset. And then you can keep a car as the healthy spouse, and you can keep, and the car doesn't have to have any value caps on it. So, in theory, somebody could have a Lamborghini as their exempt car, although at that point you may want to try to sell it to, for other reasons. And then the healthy spouse can keep the home with no lien being placed on it. They don't have to sell it. They get to reside in their own home still. So those sorts of things are not available for the healthy, or for the spouse receiving care. It's not available to be spent down. They don't have to spend down through that before that spouse receiving care can actually receive Medicaid assistance. Okay, so I did just get a question. If I get married and my husband has his sister to take care of the trust that he made for the home, farm, vacation homes, if he doesn't have my name on the trust to take care of it or anything, what happens when he dies? So if I'm understanding, and if I'm not understanding this correctly, let me know. But so the first question here is, if I'm not on, I'm assuming as like a trustee or manager of the trust, what happens? And if it's a separate trust from prior to the marriage, which happens a lot as people get married, the spouse who's not a trustee or not listed as a trustee doesn't necessarily become a trustee just because they're the spouse. So that can still, sometimes spouses don't have each other as trustees because of remarriage concerns if they came in with different assets. And in some ways, depending on what like a prenuptial agreement might say, they may have certain things of reasons why that's the case. It's hard to know for sure. But what happens? And then the next question here is, if he wrote a separate written addendum to have money or have somebody be the primary trustee. So written addendums for things like wills and trusts, if they're handwritten especially, but if they're just not properly executed by, if they're not notarized, if they're not witnessed, it can raise a huge concern for if somebody challenges it. One in Wisconsin, what's known as a holographic will or holographic addendum, things like that, where they're handwritten or not legally valid for wills in particular. But even with trusts, you want to make sure that they're drafted properly. You want to make sure they follow the terms. You want to make sure they're notarized if there's a change, or witnessed if that's what the document says it requires for that. And especially when things are handwritten. I mean, even in states that allow holographic changes, and holographic is a fancy term for handwritten. A good example is what just happened to Larry King. What's going on right now? He passed away, and I can't remember who it is in his family, but somebody submitted a handwritten last-minute will to the court and saying this is what he wanted, this is his change. And obviously, there's a challenge going on about that by some of the former beneficiaries under the old will, because they're claiming he didn't have capacity or he was forced into it. So those handwritten changes are just never a good idea anyway, even in the states where they're allowed, because you don't have that added proof that somebody did have the capacity to make that change, or that it wasn't forged, or it wasn't made under duress. So you always want to make sure that if somebody is making an amendment to a trust or to a will, that they're executed properly, and that they are, if nothing else for a trust, you want to make sure they're notarized, so that, if I notarize all my clients' documents, if somebody came to me and said, hey, did you watch them sign this? Is this valid? I could look at my signature and my notary and say, yeah, I saw them sign it. So it adds that extra weight. You just want to be very, very careful about handwritten changes. If you have the opportunity with somebody to actually get them to go into an attorney and update it, that's always the better option, because you're going to have that added proof that somebody did, that this was not made under duress, or somebody didn't forge it. It's just always a concern of mine when somebody handwrites things, and even things sometimes our own clients will occasionally, before they come in and meet us for review, we'll see that they've crossed things out in the trust after it's been signed, and wrote in some of the changes they want to make, thinking that it was at least temporarily valid. But because it had been signed before they made those changes, those handwritten additions later on were not valid changes. So we were updating them anyway, so it didn't cause too much of a problem, but it's something to keep an eye on. So hopefully that answered your question. That can be a very complex situation, and it may take more time to sit down and really go through all of that to make sure that everything's done properly, and get all the facts and all of that. So that that's something in particular where you would want to sit down with your husband and have you and your husband come in and talk together. Especially with married couples, it's really important that both spouses are on the same page with their estate plan, because it just creates problems when they're not, for either the surviving spouse or the family, especially if there's a blended family at all, where you have kids from prior marriages. That can just add complexity to it. There's certainly ways that you can plan for it, but you just want to be very careful about making sure that you're protecting everybody involved. So just a quick get back to the, can I protect, all of my assets by just putting one name on it? The answer is no, not necessarily. Some of the things I mentioned, like the home and the community spouses, the healthy spouses, retirement accounts, qualified retirement accounts are already protected. But when you put like a bank account or just a standard investment account that was joint or was just in the spouse who's receiving care, just in their name, just by putting it into the healthy spouse's name, you're not protecting it at all. It's still countable. Medicaid in Wisconsin has what they call countable assets and what they call, unavailable assets that are not added to that calculation. And it doesn't matter whose name they're in. If you're married, that's how they factor that in. So you want to talk to an elder law attorney on that. Certainly, all of us here are estate planning and elder law attorneys, so that would be something that you want to talk about it, hopefully in advance of needing care. But there are things you can do even if somebody needs care or is already receiving care to still protect assets. So, and then I'm quickly running out of time here, but I'll try to get here through the last kind of standard question we have here is, can we speed the state administration process just by putting our kids' names on the deed to our cabin or home instead of passing it through our estate? I get this question a lot for both Medicaid concerns and long-term care concerns, and for just ease of administration concerns. And there's a lot of three really big reasons that you don't want to do things like this. One is there's tax concerns. So when somebody buys a piece of real estate, they have what's called a tax or a cost basis in it. And then when they sell that property, the difference between the sale price and what their current cost basis is how they factor out, if there's any taxable gain on it. When you pass away and that property goes through your estate, it gets adjusted to fair market value so that when the kids turn around and sell it, they don't have to pay any capital gains tax on it, or very little, depending on how long they hold on to it. If you transfer it to somebody for less than fair market value, meaning you just gift it to them or just put their name on the deed, you're transferring your cost basis to them. So it can get really tax inefficient to just put the kid's name on something that they would have received a better tax basis adjustment through the estate. And it also is a huge loss of control for a lot of people, especially for nursing home concerns, where you're now putting it into someone else's ownership, that you no longer own it, and you don't have any necessarily occupancy right or anything like that set up. So now, if your kids wanted to, and hopefully they don't, they could kick you out or sell the home, and there are stories of that happening. So there are better ways to do that planning, certainly, and safer ways for you. And really the final reason that that's a bad idea is when you put something in someone else's name, you open it up to what happens to them. And by that, I mean, you open it up to their, debt liabilities, potentially their divorce liabilities, their legal liabilities, and their own estate plans. Because if they pass away as an owner, well, their share of that property gets split by the way their estate says it does, unless it's like a joint tenancy on the property. But you want to be very careful about how you do that. And generally there are, many better ways to deal with passing on real estate or protecting it from long-term care without opening it up to those sorts of liabilities. So one last thing before I go, I'm a little over time, is just a reminder that if anybody would like to set up an initial consultation with us, to fill out that feedback form, that evaluation form, or if you want to reach out to us directly and call our office, you can do so as well. But those are complimentary. We schedule them for about 2 hours. Sometimes they take a little less time. Sometimes they take a little longer, depending on the complexity of the topics we're talking about and how much we need to go through. But they don't cost you anything to come in and talk to us. By the end of those meetings, we can usually give you a pretty good idea of what cost would be. But just one last reminder, our next week's topic is on wills versus trusts. So really the big differences between how those work with somebody's estate plan and how you want to use them in order to use them properly. So if you're interested in that topic, please join us next week as well. Thanks you all for joining me. And